I'm Bill Auten of Auten Claims Management.
I'm Chantal Roberts of CMR Consulting, and welcome to the Art of Adjusting podcast.
Today, we're going to talk about life as an insurance adjuster from the perspective of property, auto, liability, or workers' compensation adjusters. Our goal is to bring interesting topics in the world of claims adjusting to people who are working as an adjuster now and to people who are considering a career as a claims adjuster. Hey, Chantal, how are you today?
Doing well, thanks. How are you?
I'm doing pretty good. The weather is really beautiful here. We're going to see 90 degrees this week, which is really unusual for May.
Yeah, I would think so. So far north, it is very humid down here in Kansas. So
Same,
we're
same.
we're we're already starting to do a little sweating a
Yeah.
little bit.
Well, today we're going to talk about litigation and lawsuits and all that fun stuff. And
Yes.
we're not attorneys, so we're going to be talking about this from the perspective of claims professionals only. And our involvement in litigation, sometimes it's more involved than others. Um, as an independent adjuster, I'm pretty far removed from that process. I'm unless the attorney calls and wants some additional investigation, which actually happens quite a bit. But I'm not in litigation management in this, end of the business. I was more involved as VP of claims at the carrier I worked at. But so we can talk around the edges a little bit and kind of let adjusters and possibly policyholders and claimants know what the litigation process is and what all the magical parts of a litigation uh, happen to be.
Yeah.
So
Well, I was
I've
gonna
got, yeah, go
wait.
ahead.
Well, usually I am, of course, promoting my Once Upon a Claim book because that's the new book.
Yeah.
It is for consumers, and I don't talk much about litigation because by
Hmm.
that point, they're handed off to an attorney, and their attorney should be helping them. Although I do mention attorneys every once in a while. Uh, This book, The Art of Adjusting, which is what this podcast is named after, is meant for adjusters, and that's who this podcast is actually meant for. Although everybody is welcome to listen to us nerd out about it. But yes, you're right. We are not attorneys, don't take what we say for law, yada, yada, yada. However, I found that chapter that I was looking for. It is
All
chapter
right.
6. And you will see right here, like on chapter 6, I have this great big old page that says, like, the goal of claims departments is not to pay claims, which is absolutely 100% false.
Yeah.
But that is what a lot of people think.
Yep.
And so we'll be talking about that, like what leads into lawsuit. And spoiler alert, we are currently working with a plaintiff attorney or a trial attorney on trying to get him into the art of adjusting to come talk to us from his point of view. Because I know as an expert witness, I have learned a lot seeing the other side, the other point of view, having been hired by the other side and the other point of view. So
Yeah.
it's very good, and I like to expand everybody's, you know, breadth on that.
Yeah. So the book is Once Upon a Claim. We'll
Uh-huh.
say it again so the algorithms pick it up a little more.
Yes.
And it's a great book. I'm on chapter, I think, is it 4 or 6? I can't remember. The one with the fish.
The earthquake fish,
Yeah.
I do not know. I don't even know if I have them like
They're
numbered.
not numbered. I had to
I don't
count.
think they're numbered. I think what they are is in groups. So the first section is kind of like, this is your policy. This is what you need to know about your policy. Because again, thinking about what consumers are knowing and knowing that I have to kind of layer things in, because one of the questions that people have been asking me in interviews is, what's the most complicated thing to have talked about? And I said co-insurance.
Mhm. Yeah.
Co-insurance. And they said, well, how do you do that? And you're like, you just have to layer it, so
Hmm.
like you would have to read all of these stories up to when we get to the co-insurance. And I still don't think I did a good job on it. Anyway, that's bygones. But yes. And then you're in the property damage, and then liability, and then auto, and then there's a last section which like kind of entails everything, like attorneys or reservation of rights letters or whatever.
Awesome. I'm looking forward to reading the rest of it. And the Art of Adjusting is another great book. And I keep giving mine away to clients or people that could use it. And at
You know
any
what I'm gonna
given,
do for you? I'm gonna make I will make a link for everybody, because it is actually $34.99. I'm gonna make a link to where everybody can get it cheaper,
cool.
and y'all can order it and just start giving it out to clients. Maybe put your
Yeah.
stamp on it or whatever. So
Yeah.
there you
Awesome.
go.
Great idea. What are we talking about again?
Litigation.
Oh boy.
Yes.
So,
We're talking about attorneys.
yep.
And you know, it is something that every adjuster tends to get their hackles up on. And I think newer adjusters tend to be intimidated by attorneys, which is perfectly normal. I mean, I remember being intimidated by attorneys until I just realized, you know what? Their bark is kind of worse than their bite.
Hmm.
What's the worst they can do? Sue you. What's the worst they can do? Name you in the lawsuit.
Hmm.
Okay. Defense counsel, which would be, you know, the defense counsel for the insured or defense counsel for the insurer, the carrier, 9 times out of 10 can get you removed.
Right.
So you personally, so you don't need to worry about um, having your assets seized or, you
Right.
know, anything like
Right.
that. Yeah.
Well, to drill down and actually talk about what a lawsuit is, what its purpose is, and what the outcome could be. Um, we in the liability side of claims generally see lawsuits against our policyholder, and the purpose of that lawsuit is that we couldn't reach some agreement with the claimant or their attorney prior to that lawsuit. Um, and sometimes there's zero effort made to uh, to come to an agreement. Sometimes our first notice of the claim is a lawsuit, and what tends to happen there is that we get defense counsel assigned. We investigate it as best we can, kind of behind the eight ball. But those lawsuits, when they're filed, as I said, it's because they can't reach an agreement, and if they haven't even tried, then they're just, I guess, going for broke. And sometimes it's a Hail Mary. Sometimes it's a case where the damages are so severe, and that they just feel it's best to just go ahead and sue this prior to having any reasonable discussions about settlement. I'm not sure I agree with that, but if you've got a case that if the attorney has a case that they know or they feel that it's worth more than any policy limit could actually compensate for, then they might just throw it into suit then too, I guess. I can't read their minds. I don't know.
Yeah.
But they
No,
should just call me because we could probably talk it out.
we probably could. And it is always disappointing when we start off with a lawsuit, but let's take it back a step.
Mhm.
Let's say that we had the claim, we've been investigating, maybe there is not an attorney yet when we start negotiating with the third party claimant. And at that point, communications break down because they think, as we've been discussing for the last two podcast episodes, we've been discussing what damages are, what liability is. Maybe they don't understand that we're not accepting full liability. Maybe they don't understand that we just don't do 3 times meds.
Mhm.
You know, maybe they think that we should pay them the same amount that their brothers, cousins, uncles, girlfriends, sister-in-laws, next door neighbors, you know, mother got because she had the very same injury.
Right.
And, you know, that just, that's not the way that it's done. And that is the consumer aspect of it, but we're talking about the adjuster side of it. And so they get an attorney. One of the first things that you, as an adjuster, would have to do is when the claimant says, okay, I'm going to get an attorney, fine. You cannot prohibit them from getting an attorney. You can't offer them more money not to get an attorney. They have that right. And
Right.
sometimes, honestly, I'm going to be honest with y'all, it has been easier when there's an attorney involved. Excuse me. Because the claimant is so entrenched and it's personal for them. And I totally get it. It is very personal. They experienced that pain. They experienced that loss. They experienced that suffering, that they don't have an objective viewpoint. And so
Right.
sometimes you're like, oh, thank goodness they're going to get an attorney.
Mhm.
But let them get the attorney. You yourself will say, great, here's what's going to happen when you get your attorney, when you sign the contract, have them send me over a letter of representation. They're going to know what that is. And then I cannot speak to you anymore. I can only speak to the attorney.
Right. And there are some cases that I never make a recommendation that someone gets an attorney, but like you say, sometimes it works out better if they do. And one of those cases is when someone is on Medicare,
Mm.
because the process for Medicare to make a claim against, put a lien on any of the settlement, they have to have first, you know,
Right.
completed their payments,
Yeah.
and that takes a long time. And so does the resolution of the injury itself. You may be 2 years before the injury is done, and medical bills keep piling up. And if Medicaid is involved, or Medicare rather, Medicaid puts liens on too, but we're
Mm.
talking about Medicare here. And, that involves, for the most part, people over the age of 65. So you're talking about basically elderly people trying to navigate a claim that's a very sophisticated process
Yeah.
that also involves this CMS element where they're going to make a claim against the settlement that's made, and trying to explain that to someone who's been injured. And all they want is compensation for the injury that, they may be completely entitled to because of liability, but you've got this waiting period, and you've got paperwork, and you've got to get the conditional letter and get that taken care of first. And they don't want to hear that, first of all. And second of all, they probably don't understand how that works. And third, they probably think we're making it up and lying to them so that we,
Because
can
we're the big bad insurance
yeah,
company.
because we make so much money by delaying claims.
It-
It's
it- we should have, I'm going to put that down as a topic because that is one of my pet peeves. And I think we really need to have a convo about that. How, yes, insurance companies make money. Yes, they make a lot of money, but that is not the only way they make money. Okay, anyway,
yeah.
going back to litigation, and you are absolutely right. I don't think I have ever said, please get an attorney. I don't think I've ever said that, but I have been relieved when they have gotten an attorney. I do want to point out one thing that I think is also very important, and I do think we may get some hate mail from like our three listeners, but I don't think any of them are public adjusters. So who knows?
There's
But
more than three. I see the numbers. There's a lot more than three.
no, I think it's the same three people listening multiple times.
Oh,
Uh,
that could be.
Yeah, I don't know. Anyway, um, hi Brandon, as our one listener. And anyway, uh, I happen to have a case, and in this one case, there's a public adjuster,
Mm.
and the expert for the insured, it happens to be a bad faith claim. So in this instance, the insured has filed litigation on the carrier, which is opposed to what we were talking about with our third party. But anyway, our uh, plaintiff expert was upset with the fact that the carrier did not solely correspond with the plaintiff or the public adjuster.
Public
And
adjuster. Oh.
yeah, and when asked, this expert says the carriers never can point to any kind of litigation or regulation that supports their theory that they can talk to the insured. And I said, well, alternatively, you can't point to anything that says that we can't. And I think that that's a very big distinguish point that we need to talk about. Just like I mentioned earlier, when your claimant is, even if it's first party, third party, doesn't matter, has an attorney, there's that client attorney confidentiality. And then we, as the carrier, can no longer speak with the claimant, third party, for example, first party. But to the best of my knowledge, I know of no state or any kind of confidentiality agreement for a public adjuster. So in that particular instance, if there is a public adjuster, you can still correspond with the insured. And I highly recommend that you do, so that there isn't that um, bottleneck of miscommunication.
Yeah. So in some case, a lot of the public adjusters I've worked with, I've known for many years, and out of professional courtesy, I respect their request to just deal with them. Um, but when it comes to maybe getting a proof of loss or something, if things are going slow or getting delayed, I have no problem contacting the insured directly because I can. And but that's never contact with the public adjuster. Sometimes it can be a little bit of a hassle, but fortunately, I don't do much of that anymore. So
Right. Not really the point, but I did want to illustrate the difference
yeah,
between contacting when there is an attorney involved. You can only contact the attorney, and contacting when there is a public adjuster involved. So when you receive that letter of representation, of course, you would put that in there. Now, you would go ahead as an adjuster and try to settle your case just like you would any other way. I mean, just because they've got an attorney doesn't increase the value of your case at all. Um, and let's say we still can't get to settlement. We still can't get to resolution, which happens. It happens
mhm.
all the time. So a lawsuit, or the attorney has threatened to file a claim, or threatened to file a lawsuit at this point. What do you do, Bill?
When they threaten to, they usually don't threaten. They usually don't say something along the lines of, "Well, if you don't do this, I'm going to sue the matter."
Really?
Um, I
Wow.
mean,
I guess I have nice attorneys. They've always, I mean, they haven't always done that, but
I th- I think it's more of just a suggestion, like, can we move this along? I haven't heard anything. I haven't heard your offer yet, and we're kind of waiting as to whether we should file suit or not. I mean, if you want to take that as a threat, I guess it's a threat.
no, no,
But they've never said like, you better do this or I'm going to sue. I mean, we just don't have those conversations.
no, I
Very,
think, when I have it, it's okay. So I can offer $45,853.17. And unfortunately, that's my max. I don't have anything more. And they would be like, no, come, to uh, 65,000 or whatever. And I can't. Okay, well, then we're going to file suit, and we will let a jury figure this out. That's what I
yeah.
mean by threatening a lawsuit.
Yeah, it's more like they're just telling us that they're going to do
They're
it.
going, okay,
You know,
all right,
I
they're
don't.
going to,
I've never felt it like that. Yeah, yeah. The
it's not
threat
like they're going
thing.
to take us in a back alley and,
Yeah,
and hit us over the
it's,
head with a lawsuit.
roll it up, bang.
No,
Um,
no. Um, okay, so that's what I'm calling quote unquote threatening with a lawsuit, or
yeah, I mean, they tell us that they're going to do it. Sometimes the initial offer is just so low to them that they'll respond by saying, well, if that's all you got, then we're just going to put it into suit. And again, they're not saying it to threaten. They're just saying, well, if that's where you are, yeah, we probably should litigate this and handle it that way. Um, because they know at that point they're, probably going to have a, pre-trial conference with the judge, and the initial offer will be brought to the table, and the judge will try and force things to happen. But that doesn't always work either. Sometimes they still can't reach an agreement. um,
I do want to point out, when you hear that there is going to be a lawsuit, either if that's the best you got, I'm going to file a lawsuit, or we'll just go to court, or however they say that, again, I call that quote unquote threatening a lawsuit or whatever.
mhm.
As an adjuster, put in your file, and I'm going to tell you another story in just a minute, but put in your file as best practices a note with stars or whatever. This claim is being handled in anticipation of litigation. And then, like, some more stars. And that's all you need to put in that one particular note. Okay. So I'm going to go on and talk about this particular note. The note says this file is being handled in anticipation of litigation. As soon as you, as an adjuster, hear, all right, I'm going to file suit, or I'm going to go to court, or we can just figure this out in court, or however the attorney happens to say it. I have heard from attorneys that, defense counsel, that is, defense counsel, that this is a nice bright line in the sand
Right.
where because opposing counsel will be able to get a copy of your file. And it may or may not be redacted. It depends. And which is one of the reasons why we Bill and I talk about how to write notes well and all of this kind of stuff. But it's a nice bright line in the sand to say, okay, everything above this line, we're going to be talking about litigation, which then is a attorney-client privilege for the carrier and the defense counsel. And plaintiff counsel should not get any of that. Now, likewise, alternatively, I've also heard defense counsel say that didn't mean anything. Blah blah blah. I say, what could it hurt?
Yeah. Recognize that bright line, make a note
Yes,
of it, and handle your file accordingly. Um, the file discovery is something that we should all kind of be concerned about, especially in, I would say, first party lawsuits against the insurance company. Um, Possibly third party claims, if you've got commentary in there about liability and damages that, would could potentially be harmful. Um, you know, that's something I guess to be concerned about. But I am also not a fan of hiding things in the file for the sake, we still need to convey this information. And if the injury is
absolutely.
really bad, we got to tell them. We can't
We
just say, well, he lost his leg, but, it's not that bad.
Yeah, no, no, no,
Can't
and
do that.
I'm not saying that by any stretch of the imagination. And of course, it should be said again that just because you are in litigation, you are not changing the way that you are handling your file.
Right.
If it's a third party claim, you are still sending those 30-day letters to the insured saying, hey, we're still in lawsuit. Let me know, if you need anything, or defense counsel is attempting to settle, or we're going to mediation, or whatever. You have to, of course, be careful with what you're saying, because then you are getting outside of attorney client privilege. But that's probably a little more advanced. So anyway, we've just gotten the lawsuit in, or we've just had the, what I call, the threat, or the acknowledgement that we're going to have a lawsuit come in or whatever. And so we
Yeah.
would put that bright line in there. in our notes saying this file is being handled in anticipation of litigation. And what I always say when the attorney says, okay, then I'm just going to file suit, I'm like, okay, great. Thank you for that. Uh, I would appreciate it if you send me a copy, a courtesy copy. That's what it's called, courtesy
Yep.
copy. And he or she may or may not. It's nice when they do. Then you pick up the phone, call the insured. You must call the insured, guys. Please pick up the phone and call the insured and explain to them because they are going to freak out
Mhm.
when they get served. They are going to freak out when they get served. And if you just send them an email, they may ignore it or whatever. So please pick up the phone and call them and explain, okay, here's what's going to happen. You're going to get a lawsuit. There may be some other pages attached to it, some kind of discovery or motions or whatever. I need all of that. So send all of that to me the moment you get it, because the clock starts ticking at that time. And if you don't send that to me, we've basically admitted to what the other attorney has said. So if he says, you're ugly and your mama dresses you funny, and we don't respond that we're rubber and he's glue, you know, then we're going to be in a whole world of hurt. And the attorney or the insured, excuse me, the insured understands when you're talking, I don't feel that that's talking down to them. Maybe some do. I don't, but I mean, they understand what you're saying, that you've, broken it down to them. I also pick up the phone and I call the retail agent because again, a lot of times the insured does not understand, and picking up the phone and talking with the retail agent, having that communication helps out a great deal too. Because as we've talked about, Bill, you and I, that agent lives in that neighborhood. They go to church together. They have little league together and all of that kind of stuff.
And sometimes you'll find that the insured will be the first to know that it's been sued. You won't, like, you may have an open file, you may have talked with the claimant or their attorney ad nauseum, and then you're waiting on medical records or something, and all of a sudden the insured calls panicked because they just were served a lawsuit. So that happens too.
Be sure, if you are speaking to the insured and the agent, follow up in a letter. Please mail that letter in addition to emailing it. The reason why I'm stressing these points is again because of this particular file that I am working. A lot of these carriers are now using these internal text messages that go automatically to the insured's email or whatever. And I don't think these insureds are grasping, or these claimants are grasping that this is an email about their file,
Mhm.
because I see the headers and everything. And it's like, carrier wants you to know an update about your file. And why, frankly, I would ignore that too.
Yeah, it
Uh,
becomes kind of white noise in your inbox, and
exactly. But if it
might even
says,
go to spam.
it probably does. But if it says carrier wants you to know about a potential lawsuit, or I need to talk to you about a potential lawsuit about this claim, data loss, blah, 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 then I'm probably going to pay attention. Anyway, there you go.
So here's why insureds freak out when they're getting sued, and it's because their name is on the lawsuit as the defendant.
Yes.
And one of the things with lawsuits that I often have to explain to people is that when they sue the matter, they're suing the policyholder, in not the insurance company. They're not suing the A policyholder can sue the insurance company if the insurance company is not doing what they promised under the contract. That's different. But when an injured party has a claim against a property owner, let's say, they're going to be suing that property owner, not the insurance company. The insurance company is just going to step in the shoes and
Mhm.
pay the claim or defend it. And the reason that's important is that a lot of times we run into familial kind of disputes where Aunt Peggy came over to visit and tripped on the stairs and fell and got hurt. And she's making a claim. And I've actually had, over the past few years, I've had several cases where it was a family member kind of a deal. The uh, they got an attorney, conversations didn't go the way everybody wanted them to go, and the attorney decided that they were going to file a lawsuit. And then the property owner realized that, Aunt Peggy, you're suing me.
Mhm.
Aunt Peggy says, no, I'm just going after the insurance company. And no, Aunt Peggy, my name is on the lawsuit here, because that's how it works, people. So
Yeah, yeah, and that
and
is
they'll
something that
drop the suit in many cases because they don't want to have that animosity among family members. Um,
and
so
and
now,
that's just something to understand as well, and when you get that lawsuit, adjusters, be sure to explain that
yeah,
to
yeah,
your insureds.
yeah. And when back when I was doing TikToks, I did one on that topic,
Yeah.
and a guy said that that I shouldn't be sending that message out, that that is harmful to people who have legitimate claims, because then it makes them feel like they want to withdraw them. And I'm like, what? If I'm not in this, I'm not agreeing with that point of view.
Mm.
I think they should understand the workings of litigation and a lawsuit, and that they will be suing that other party.
Yeah.
And
Their
it doesn't,
attorney should explain that.
they should.
Yeah. One of the things, the horror story, urban legend, what have you, that I have always heard, and this is another thing that I want to bring to adjusters' attention, is when you get the lawsuit, there are, like I said, often other pieces of paper that go with it, such as motions to disclose or requests for admissions or something to that effect. There's all these little bitty parts in addition to the complaint. The complaint is the actual lawsuit. This is the thing that says you didn't settle, you're at fault. We're asking for the jury to determine how much money is owed, which brings up a very good point that we need to put a pin in real quick. We need to talk about excess verdicts and when we get that lawsuit real quick. But I'm going to finish this thought, this urban legend, whatever. Okay, so the urban legend goes that this adjuster received the lawsuit and she assigned it off to defense counsel, but she only forwarded the complaint, not any of the subsequent pages.
Hmm.
The request for admissions, the request for productions, and I'm not going to explain what all of those are. It's kind of a more advanced thing. And again, not an attorney. Anywho, and the attorney just responded to the lawsuit and didn't respond to the request for productions, request for admissions, yada, yada, yada. And anyway, the whole thing, short story, went south
Hmm.
because the attorney didn't do this. I have never worked with a defense counsel who was that slipshod, I guess I would say, who failed to pull a copy of the entire lawsuit themselves, but I guess it could happen. So, my point is when you get a lawsuit, forward all of the pages to defense counsel. They are going to want a certified copy. Go ahead and request it automatically. They are
Mhm.
going to want an entire copy of your file. Go ahead and request it and then send all of that over to your defense counsel. But don't wait on certified copies and copies of the policy. Get the lawsuit and all of the pages over to defense counsel because again, clock starts ticking. If you don't answer it in time, 10 days, 20 days, 30 days, I have no idea, it depends on your jurisdiction.
Mhm.
Then you have just admitted that, you're ugly and your mama dresses you funny.
Um, yeah. So, oh,
Lawsuits with the jury, please let the jury determine the price or whatever.
the value of the claim. So they used to put at the end, they would, after all the causes of action, they would tell you all the bad things you did. And then they would say, we hereby demand $1 million or whatever it is. They don't do that anymore. Not,
No,
not in New York anyway.
no, they don't do it anywhere.
Yeah, now they say that the value of the claim exceeds all jurisdictional limits.
Mhm.
And
So,
someone explained that to me once, and I think it was because when they were putting the amount in, and the jury came back with a higher award, it would then be reduced to whatever their demand was.
yeah,
So
basically.
they stopped doing it.
It's
So,
basically a catch-all. But the problem is that it's basically a catch-all.
mhm,
So your policy limits could be, and we're using homeowners for examples, 500,000, whatever, 250,000, I don't know. Or we could talk about commercial, which could be 1 million, 2 million for general liability. Who knows? However, the point being, well, you could have a jury come back with a nuclear verdict, or you could
mhm,
have a runaway jury, and they, say it's $5 billion or whatever. And you're like, yeah, that is check, please. We don't have that policy limit. We've got a million policy limit or whatever. Point being, again, adjusters, in addition to putting that note in the file, please read the lawsuit and, of course, make a note in the file. Plaintiff is alleging this, 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 and this. They have asked for, quote, jurisdictional limits. And then what you need to do is send the insured a letter and have a conversation with them, probably all at the same time,
mhm,
and explain what that means, which is, okay, jurisdictional limits. They could come back with a $3 million lawsuit. Your limits, if it's a business, let's just say it's 1 million. If they came back, the jury came back with a $3 million verdict, we would pay the million, and you would be responsible, Mr. and Mrs. Insured or corporate insured, for the 2 million, unless you
mhm.
have umbrella insurance or excess insurance or something to that effect. And so you need to put them on notice.
Yep.
I know
Yep.
you and I have talked about how you have to notify plaintiffs of every insurance. And I say, that's silly. How am I supposed to know every insurer
It's
that?
it's a weird, yeah, it's a weird regulation that they put in
But
place here.
yeah, but on the flip side, again, you need to, as an adjuster, because here is what's going to happen if you do not do this. Guys, this is how important it is that you do this. If you don't do it, the insured can then turn right back around and sue you saying, y'all didn't tell me about this. And then
Mhm.
that's bad faith. They can allege bad faith, which is when I get involved and yada, yada, yada. And you just don't want that.
Right.
Um,
And that's where the lawsuit against the insurance company actually happens, is when the policyholder feels like they were not taken care of by the policy, or the carrier didn't meet the promises that they made under the policy.
Right, which is
So,
why I always say, and I know a lot of people disagree with me, but I always say you could still have bad faith out of your third party claim simply because of the fact that you, adjuster, dropped the ball.
right.
Uh, um, by the way,
Especially in a case where the potential for an excess verdict
yes,
exists.
yes,
So if you've got a policy with $100,000 limit, and you get a demand for $100,000 and you tell them no, and then they sue it and get 200,000. Now that policyholder has to make up the difference, and they would be probably within, it would be reasonable for them then to sue the insurance company for not negotiating that claim properly, and settling when they had a chance to.
right. I am just flipping through the art of adjusting to see what I've got here? What else that we are talking about? Oh, the duty to defend is broader than the duty to indemnify. We
Yeah.
have mentioned that previously, but it would probably be a good deal
Yeah.
to discuss again.
And that's from your book, The Art of Adjusting, that you wrote?
Yes, the art of
Yes.
adjusting. This is, guys, okay, so FYI, this is what our podcast is named after. And it's a little bit older. It is a little bit out of date. I will tell you this. I have learned that it's a little bit out of date, but you know what? That's okay. But it was published in 2021. The things that I learned that it was a little bit out of date is the interpretation of bodily injury codes and stuff. I have a friend who is a doctor, and he spoke at the Greater Kansas City Claims Association about what um, the new way to interpret CPT codes and all that. So it was great.
Yeah.
It was very fascinating. Anyway, but yes, Art of Adjusting, written for adjusters. So it's a little bit more in depth than Once Upon a Claim, which is the consumer version of that book. So anyway, duty to defend.
Duty to defend. So I can explain this. When you have a lawsuit that has some causes of action that are not covered, like intentional act might be one. Um, Sometimes it'll be certain types of assaults are not covered under the policy. So if you get a lawsuit that says a couple of those things in there, the it would appear that there is no coverage. However, if they have another cause of action that alleges some sort of negligence, especially in an intentional act, the best example is the accidental shooting.
Yeah.
So you got somebody in a bar fight. Guy pulls out a gun. He shoots the gun toward the claimant, hits the claimant. That sounds like an intentional act. He shot the guy.
Mm.
That's not covered. But if they allege that he, shot that guy in one cause of action and assaulted that guy in another cause of action, and then in another cause of action, they say he negligently pointed the gun in the direction of the claimant.
Mm.
Well, now you've got coverage for that cause of action, not the other ones, but that one. And you only need one in there. Now you have to at least defend the case.
Yes. And it's known as pleading to coverage,
Mhm.
and a plaintiff attorney would not be worth her weight in salt if she did not plead to coverage.
Yep.
And even if it's a scintilla, meaning just the hair's breadth of coverage, then that's what she's going to do. Now, again, what we have in Bill's example is an excellent example of some covered and uncovered, or potentially covered and uncovered claims. So we have at least two potential causes of loss or actions or whatever, that clearly aren't covered, because they're intentional. And
Mhm.
we've got this one here where the plaintiff attorney has pled towards coverage. You, as an adjuster, have to do a reservation of rights letter, because you can't lead the insured down the garden rose path thinking that the whole thing is going to be covered. We are going to provide defense for the lawsuit. Don't get me wrong, but you, as the adjuster, need to send out a reservation of rights letter. So you send out a reservation of rights letter saying, okay, intentional acts are not covered. However, this may be covered. We don't know. We're defending. Here's your defense counsel. Please cooperate with them. Here are your duties, yada, yada, yada. Okay. Send that out. And of course, call your insured, talk to them, call your retail agent, talk to them, explain all of this. It is confusing, it is upsetting, all of this kind of thing. And then, depending on what state you are in, this opens up a whole different fun little, you know, situation, because now you may be in what is considered to be a conflict as a carrier, because you've just reserved your rights saying, yeah, we don't know if this is going to be covered or not. We know these over here aren't going to be covered. We don't know about this one over here.
Mhm.
So we're going to continue to defend. We're going to be continue to review. But if we find that all of it is not going to be covered, then we are going to pull our defense, right? Because we don't defend you if it's not covered. In some states, Mississippi, California, uh, they say you have now entered into a conflict. And now you've got to split the file, of course, between coverage and defense. So now you've got another adjuster and, your coverage adjuster and your defense adjuster. And then you got to hire like a third attorney, because then you're going to have because your defense counsel then becomes your coverage counsel. And I know this sounds confusing, guys, trust me. Your defense counsel becomes your coverage counsel. You got to hire a new defense counsel. And then because you've got a conflict, you got to hire a third or a second defense counsel, basically your third attorney. And that's you're going to be your Kumis or your Moeller counsel. Fun.
Yeah, great
Jump
fun.
jump in here, Bill, to help explain that, because I know I've just confused everybody.
Well, when an insurance company hires an attorney to defend a policyholder, that attorney's obligation is to work in the best interests of that policyholder. So they can't really comment on coverage. They can't, like, if they see a coverage problem, they really can't bring it to the table, because they're they will know that the insurance company will then remove coverage, and they can't, they just, it's against their interest in their policy, and the policyholder's interest to do that. So we as adjusters have to be mindful of the coverage issues and recognize them when they happen. And then and here we don't do the reservation of rights. We can talk about that a little bit, but typically you'll want to notify the policyholder that there's a coverage issue, whether it's a reservation of rights or a full-on disclaimer of coverage. Get that to them. Here in New York, the reservation of rights doesn't work. You have to disclaim coverage,
Yeah.
and you have to do that as quickly as possible, meaning that you have to fast track the investigation.
Mhm.
And then if there's a dispute with the insured's interpretation of coverage and the insurance company's interpretation, they might hire an attorney to sue the insurance company, where then you've got to have defense counsel that's just a coverage person defending the insurance company from that potential third. Well, that wouldn't be a third party action, would it? That would just be a
Oh, that brings up a good point, though. In certain states, they keep mentioning in Texas, and I swear I have never seen this in Texas for your long arm statutes and things of that nature. The only time I have ever seen it, where a claimant can sue an insurer, is in
Mhm.
Louisiana. Um, and they mentioned California, they mentioned Texas, and honestly, I've never seen it there. It's not to say that it doesn't happen. I just never have seen it. I know it happens in Louisiana. It happens in Louisiana because they have the Napoleonic code rather than the common law code of the English thing, which is the rest of us. Uh,
Interesting.
but so you can have quote unquote bad faith from a third party claimant rather than just a first party, but that is, we're getting off into the weeds in that particular area. But yeah, you're absolutely right. You do have to fast track some of this, and I just want to give you, like I said, in some of the interviews, I just want to give you enough information to become dangerous. So when you maybe stumble across this kind of thing, you go, oh, you recognize it, and then you can ask about it.
Yeah. So One of my notes here talks about the parts of a lawsuit.
Oh,
So
yeah.
I'm going to list them real quick, and then we
Okay.
can just have a conversation. So it starts off with the complaint, the summons, and the complaint. And the complaint has all the causes of action that tells the insured how bad a person they were and what they did wrong. And then there's the answer, and that's where the defense attorney basically answers that complaint. And each cause of action is answered like, no, he didn't, no, he didn't, no, he did, or something along those lines.
Mhm.
After that comes discovery, and that's where both sides turn over all their investigation or information to each other and enter it into the record so that everybody knows what all the facts of the matter are, and that a judge can look at the all the pleadings and make sure they're correct.
Mhm.
And let's see, then there's pretrial motions, and then the trial, and then post-trial motions and appeals. But so anything in there you want to talk about?
Well, again, on your complaint, be sure you pay attention. It's usually going to be on your last page, to how much they plead for, and it's usually going to be something to the effect of whatever the jury decides, because that's when you need to talk about your um, excess umbrella coverages, all that kind of stuff.
Right.
Um, with your answers and your discovery in discovery, this is when your claim file is going to come up. And this is usually when I get involved as an expert, because then I am trying to figure out in the first party instance, because you have the same, by the way, guys, if it's first party suing carrier or third party suing the insured, they're all called the same
Mhm.
parts. This is usually when I get involved, because I then get a copy of the file. I get a copy of, hopefully, the plaintiff file and the insurer file, and I read both of them and try to come up with, did you pay attention to those good faith claims handling, those unfair claims practices acts that Bill and I go over at the first of every year, because
Mhm.
it's that important. I would love for you to put me out of business. Please put me out of business. Buy all my books and put me out of business.
There.
So, yeah, there's that. And then you're going to go into the judge, because the courts are so overwhelmed, the judge is going to push you into mediation. And that is when you sit around and you try to settle it again,
Mhm.
just like you did before the lawsuit. So go back to your supervisors and everything and go, guys, we've already spent 50,000 in defense costs. Even if it's in-house counsel, you've spent 50,000 in defense cost. It's
Mhm.
coming out of some pocket somewhere.
Yep.
Um, so don't start with, we're not spending anything because it's in-house counsel. No, yeah, you are. Yes, you are.
Mhm.
Um, try to get some money on the table. Let's settle this thing. Um, because a good file is a closed file. A good file
Yep.
is a closed file. And it's not our job to not pay claims. Our job is to pay covered claims.
For a
Covered
fair
claims.
for a fair amount.
For a fair amount. Um, that's what we're being held. That's our standard. Anyway, so yeah, and then when we do happen to settle, or we go all the way through the jury or whatever, um, let's say that we decide not to fight it, or we go through all the way to appeals or whatever, the attorneys usually take care of closing it out with some kind of dismissal or a release or whatever, so that it's tied up and nobody can come back and come back afterwards or whatever. There is this statute, by the way, FYI, sometimes 2 years, sometimes 3 years, sometimes 1 year, depends on your state, again, as to when the claimant needs to file a claim. And sometimes you got to tell them that,
Mhm.
when that is.
Yeah, the statute can screw things up. I've had a few cases where it was sued after the statute ran.
Mhm.
Um, they get thrown out, you know.
Yeah.
So it doesn't happen very often, but
Yeah.
um,
I don't, have we done everything?
I think so. I have some more notes here,
Oh,
but I think that we've
we
beaten the hell out of this topic today. So
okay. All right.
anything else that I have here, I will certainly use in a blog post about this topic because as I was making my notes, I was like, this would be a good one. So,
Yeah. Yeah. This is a
yeah,
good one. This is a good
yeah,
one. Yeah. All right. We're going to be coming back in 2 weeks. I am trying to see if we can get that attorney for our next one. If not, then we are just going to be kind of talking about, I guess, adjusting, or is there another topic that would fit really good? Because we've been kind of on this liability topic, which I'm loving, actually,
mhm,
because we have been talking about property damage quite a bit, and how everything's been bleeding into liability. So
yeah. Well, well, we have a list that we have been working off of, and I am more than happy to adjust that list and
all right.
come up with new topics. And if you're out there listening and you have something that be interesting to talk about with us, please contact us, and
Yes,
we'll get you on the show here too.
please. Yes. Okay. Well, then I think this is it.
All right. Well,
Cool.
by once upon a claim,
Yes. Buy once upon a claim, and I'll give you a link with a discount of the art of adjusting.
we'll put it right in the show notes.
Cool.
All right, Chantel. Take
Bye.
care. Bye bye.
Bye.
Thanks for joining us on the Art of Adjusting podcast, where we talk about life as an insurance adjuster.
If you enjoyed this podcast or this episode, please give us 5 stars and a review. It does help the algorithm pick us up.
Hit that subscribe button real quick and tell all of your adjuster friends to check this out as well. For independent adjusting services, go to www.auton.claims. And for anyone interested in working as an independent liability adjuster, go to the Contact Us tab to join our roster.
In the meantime, you can contact me at theartofadjusting.com for consulting and training purposes.